Good afternoon and welcome to our webinar on the must-know contract cases from 2016. My name is Daisy Bovingdon and I will be presenting along with my colleague Alison Rochester. I am a member of the Commercial Disputes team dealing with a range of disputes concerning commercial contracts and intellectual property. Alison is a member of the Media and Technology team and advises on all non-contentious aspects of commercial contracts.
This webinar will discuss the six cases which are listed on the slide there, and these provide examples of how the courts have interpreted contractual provisions over the last year. We'll cover 5 decisions from 2016 and a recent opinion published by the Inner House earlier this month. Although each case has been decided in the context of particular facts and circumstances, the legal principles arising out of the decisions are likely to have application across a variety of different contracts. For each case, we will summarise the facts, the legal issues that fell to be determined, and the implications of the decision. Finally, before we get started, there is a chat box available on your screen, so please feel free to ask any questions by typing in that box, and we'll answer them either at the end of the webinar or by contacting you directly later today.
So we begin with the Lend-Lease trilogy. This is the case of Martifer UK Limited and Lend-Lease Construction. There were 3 decisions, the first handed down in 2015 and the further 2 in May and July last year, all called before Lord Tyre in the Outer House of the Court of Session. So to begin with the facts, Lend-Lease was the main contractor in the construction of the SSE Hydro in Glasgow. Martifer was a subcontractor responsible for working on the structural steelwork, roof steelwork and roof cladding. The 2015 decision concerned whether an information release schedule formed part of the subcontract. The second decision interpreted the meaning of roofing works, and most recently, the court determined whether Lend-Lease had varied the subcontract. A brief review of the first 2 decisions. In 2015, Martifer sought declarator that the subcontract required works to be completed in accordance with an information release schedule. The court found that the documents did indeed form part of the subcontract. The pages had been initialed on behalf of Martifer and included within the documents annexed to the subcontract. However, the court considered this did not impose a binding contractual obligation on the parties to complete the works in accordance with that document. The court applied the reasonable person test, concluding that the document simply regulated the general approach to be adopted on the project. There were too many inconsistencies between the documents and the main contract for its detail to be binding. The second decision concerned whether the words roofing works included construction of the roof steelwork or whether they extended only to the roof covering. Lord Tyre rejected both parties' submissions. Roofing and roofing works are too general to have a single, ordinary and natural meaning applicable in all cases. The meaning of roofing works in a particular clause must depend upon context, reading the contract as a whole. Lord Tyre therefore looked at the work packages and their pricing to determine what was included in the term. The construction of the steelwork was dealt with separately from the roof covering in those documents. Lord Tyre therefore found that roofing and roofing works was restricted to the roof covering and not the steelwork required to support it. So this is an example of the courts looking elsewhere in the contract to assist in interpreting a term. The case then went to proof. Here, Martifer sought declarator that instructions issued by Lend-Lease had been contractual variations. So, the steelwork did not meet the specifications set out in the subcontract, and Lend-Lease had the right under the contract to issue any reasonable direction to Martifer regarding the works, including ordering a variation. Lend-Lease issued a direction requiring Martifer to carry out the work to a tolerance of 10 mm. Martifer sought to rely on an assumed tolerance of 20 mm, which it argued formed part of the contract. The court held that Martifer had failed to establish there was any such provision. In addition, Martifer unsuccessfully argued that Lend-Lease had asked for a variation to the design of the support system for the cladding. As Martifer were not parties to the design contract, they could not claim it had been varied. Finally, the court held that the easiest and cheapest way of doing a job will not necessarily be acceptable. In this case, the roof of the SSE hydro had to be curved and circular. Martifer wanted to use faceting to achieve this, but Lend-Lease felt this only achieved the desired effect from a distance. The courts were not persuaded that Lend-Lease were varying the contract by insisting that a new, more difficult and expensive way of creating a curved and circular roof was used. Lend-Lease were simply enforcing the standards already set out in the contract. So what points do we take from this case? Firstly, ensure contractual documents are executed properly and in Scotland in compliance with the requirements of Writing Act. Secondly, consider critically which terms need to be expressly defined. And to show a contract has been varied, the contract must set out the original obligation so that the court can identify what has changed. The variation must be in relation to work that you are actually required to do under the contract. And remember, a cheaper alternative method of carrying out work will not necessarily be acceptable. In applying this to everyday commercial transactions, think carefully about how you define terms and standards. Discuss the approach with your technical specialist and with your solicitor to make sure that the contract says what you want it to. Failure to do so may result in you having to carry out work that is both more difficult and expensive than you had anticipated.
Moving on now to our second case, which is iron beam services against Dynex Semiconductor. This was heard in the outer house of the Court of Session, and as with the previous cases, was also heard by Lord Tyre. This case concerned whether a buyer was able to reject non-conforming equipment under a contract, or whether, by failing to reject the equipment, the buyer could be deemed to have accepted it. The pursuer in this case was Iron Beam, who supply iron implant machines to semiconductor manufacturers. In June 2009, Iron Beam contracted to sell a refurbished machine to Dynex. In terms of the contract, Iron Beam was to supply a machine called a Varian Vision 200, together with various extras, including installation and process development. The contract included a clause to deal with the acceptance of equipment and remedies available if it was rejected. Under this clause, Dynex could elect any or all of a number of options, including requiring Iron Beam to propose a corrective action plan with fixed timescales, which, if accepted by Dynex, had to be implemented. The clause also provided an alternative, which was at Dynex's sole discretion to require the return of the equipment to Iron Beam for a refund of all monies paid and cancellation of the order. In addition, the agreement specified that the equipment was to be accepted, or not, as the case may be, under the acceptance process described in the procurement specification, which formed part of the agreement. So the machine was delivered 3 months late in February 2010, and by January 2011, some 11 months later, installation and commissioning had still not taken place. At this point, Dynex gave notice to Iron Beam that they rejected the equipment and requested a corrective action plan to be prepared by Iron Beam. Over the following years, there were protracted attempts at remedial work until eventually, in December 2014, Dynex gave formal notice to Iron Beam that the equipment had never been accepted, and giving further notice that it was rejecting the equipment. The court summarised the issues between the parties as follows. First, whether Dynex, having failed by June 2011 to exercise its entitlement under the agreement to require a return of the equipment for a refund of all monies paid, is to be taken to have accepted the equipment and was accordingly then bound to issue written notice of acceptance and pay the balance of the price which was payable on final acceptance. Secondly, whether Iron Beam was personally barred from insisting that the equipment was accepted with effect from June 2011 by virtue of its agreement to carry out further actions in order to provide a functioning system. And thirdly, in the alternative, whether Dynex was bound to accept the equipment in May 2014 and pay the balance of the price when, as Iron Beam argued, the equipment had met the process requirements and production requirements in the procurement specification and thus completed the acceptance process. In relation to the first issue, being whether by not requiring return of the equipment and repayment of sums already paid, Dynex had accepted the equipment, the court held that whilst the contract provided that Dynex had the option to accept non-conforming equipment, they were under no obligation to do so following implementation of a remedial plan. They also stated that it made no commercial sense to impose an arbitrary limit upon the time available to Iron Beam to complete any remedial action undertaken, at the expiry of which the equipment must be taken to have been accepted if Dynex had not exercised its entitlement to require return and refund. The court rejected the argument that the absence of a notice terminating a contract could constitute an acceptance of the non-conforming equipment supplied. The second issue related to personal bar, and the court in that instance held that it was not required to consider this issue, but if it had, inquiry into the facts would be required. The final issue the court considered was in relation to whether Dynex was bound to accept the equipment once the equipment had been found to meet the requirements in the procurement specification. On this point, the parties disagreed as to whether the sequence of events set out in the procurement specification continued to have any contractual effect, given that the contractual completion date set out in that specification had been departed from so significantly. The court did not make a decision on this and allowed a proof before answer to determine whether Dynex was bound to accept the equipment on the basis that the acceptance process had been completed. So while this case largely turned on the interpretation of the individual clauses in the contract, it is nonetheless a helpful reminder of two important points. First, acceptance and termination clauses should be drafted clearly, including, for example, any specific timescales for remedial action to be completed or when deemed acceptance may occur. Secondly, reviewing the main contract together with all ancillary contractual documents is key to ensure that they work together and there are no contradictory provisions. As we'll discuss in one of our later cases, it is important to watch out for terms that are interdependent and ensure that the contract makes sense as a whole. Our third case is Globe Motors, a judgment from the English Court of Appeal. As such, this isn't legally binding, but highly persuasive in Scotland. The legal issues considered here were firstly, interpretation of an exclusive supply agreement, and secondly, whether a clause requiring all contractual variations to be in writing could prevent the validity of an oral variation. As I said, this case concerned a contract for the exclusive supply of components which were used in the construction of power-assisted steering units for cars. The steering units required components called Gen 1 motors. These were supplied by Globe to TRW Lucas under an exclusive supply agreement. TRW also bought the next generation of motors, called Gen 2 motors, from a different supplier. Globe considered that this was in breach of the exclusivity agreement between the parties. The court considered whether the first instance judge was wrong to decide that the agreement covered not only the products identified in it, but also the Gen 2 motors which were bought from a third party. TRW's first ground of appeal was that the judge had erroneously extended the definition of products in the agreement to include products built to different specifications. The Court of Appeal accepted TRW's position that changes to a specification needed to be agreed by TRW for them to be brought within the definition of a product. This had not been done, and TRW Lucas were therefore free to purchase the Gen 2 motors from an alternative supplier. The judgment in this case gives a fairly comprehensive review of the important case law and interpretation, and we've summarised the general guidance on the slide. The secondary issue in this case was whether an oral variation was valid, where the contract provided that all variations must be in writing. The court did not need to deal with the point on oral variation. However, the judges took the opportunity to review the law and provide some helpful guidance. The court referred to the two leading and conflicting authorities on the matter, the United Bank case and the World Online Telecom case. United Bank supported TRW's case, which stated that an oral variation would not be valid where variations were required to be in writing by the contract. The World Online Telecom case held the opposite. The court sided with the World Telecom Online case on the basis that the judgment in that case had the support of previous authorities and texts, whereas United Bank had neither. Therefore, the Court of Appeal considered that it would have been competent to find that there was a variation, which in this case added an additional party to the contract. The court found evidence of open, obvious, and consistent dealings over a protracted period, and as such, the oral variation would have effectively varied the contract despite the provision prohibiting it. In practical terms, this decision clarifies the law on oral variations in contracts. Where the party's conduct demonstrates that there has been a variation to the contract, then that variation will be valid. Care must therefore be taken when accepting changes of practice that are not intended to have contractual effect.
Our fourth case is Ho International Limited and Anderson and another. This is a recent successful appeal to the Inner House of the Court of Session, published earlier this month. To begin with the facts, Anderson owned the share capital in Speyside Distillers, which they sold to Ho International Limited. Within the share purchase agreement, the seller had granted a number of warranties. This included a guarantee that no liabilities existed beyond what had been disclosed in respect of a pre-existing dispute with a third party. Following the sale, the third party raised a claim against Speyside. Ho's agent then wrote to Anderson's agent to give notice of the claim and to purportedly intimate a claim for breach of warranty. The notice provisions in the contract required notice to be given to a named solicitor at their postal address. The notice was in fact not addressed to that individual, and it was sent by DX. Ho settled the third-party claim and in this action tried to recover from Anderson. Anderson argued that the notice they had received was invalid. The question for the court was, did the pursuer's correspondence amount to notice of a claim? There were two aspects to be considered. Firstly, whether the terms of the letter had given the defender sufficient notice, and secondly, whether that notice was validly intimated. The Inner House held that the notice was indeed valid. The court agreed with the Lord Ordinary that contractual notices should be assessed on an objective basis, that of a reasonable person exercising their common sense in the context of the particular case. Anderson could have been in no doubt about the meaning of the notice, and Ho therefore satisfied this part of the test. Further, the fact that the notice had not been intimated in precisely the way set out in the contract did not affect its validity. This aspect reversed the decision of the Lord Ordinary. The court listed some practical considerations to take into account in interpreting contracts. When drafting, parties concentrate on the central terms. What is the property to be sold? At what price? What are the main warranties? Less time is spent on other matters, and so it is less legitimate to say parties must have specifically focused on a less central issue when agreeing wording. If courts take an overly strict approach, it will only encourage contracts to get longer, imposing greater transaction costs on parties. In relation to contractual notices, the court confirmed the approach taken in the English case of Manet Investment Company Limited and Eagle Star Life Assurance Company Limited. The standard of the reasonable commercial person is hostile to technical interpretations. Notices are often drafted by commercial people rather than lawyers, and it would be a disservice to commercial practice to treat them as technical documents. In deciding whether strict compliance is necessary, the court should ask itself two things. 1. What was the purpose of the notice? 2. What was the purpose of any particular notice requirement? The notice in this case intimated a third-party claim. The court considered that was informative in nature. If the notice had been for, say, a break clause giving notice to terminate a lease, or notice to take an option to purchase, then the notice formalities themselves may be construed more strictly. This is because those circumstances require a higher degree of legal certainty. The court must ask itself, if a particular formal requirement is not complied with, is the would-be recipient prejudiced in a practical sense? If there is no prejudice, insisting on strict compliance for its own sake serves no useful purpose. In this case, the notice did in fact fall into the hands of the solicitor authorised to act. There was no prejudice. The court also considered that sending the notice by DX amounted to personal delivery under the contract. So as a side issue, what if the notice had been sent by email? The contract included a provision stating, email shall not be deemed appropriate for the service of any notices. The court made an obiter comment that had notice been sent by email in this case, it would not have been valid. What are the implications of this decision? Do not assume you can rely on the fact that your opponent has not complied fully with notice provisions to argue that any notice you receive is invalid. If there has been no prejudice to you, then a court may consider that notice has been validly served, even if it doesn't comply with the strict terms of the contract. That said, there are many other authorities which have found on the fact that a notice is invalid because the notice provisions have not been followed. This was illustrated by an in-house decision just in 2015, which held that a notice was not effective because there were typographical errors in the address. When drafting notice provisions, discuss the practical circumstances with your solicitor to decide what is necessary to constitute notice. This decision suggests that it may be most appropriate to adopt a less is more approach, limiting the drafting to what is really required. When serving notice, do so strictly in compliance with the contract. The case law in this area is complex and sometimes contradictory, and so we advise you to take a cautious approach.
Turning now to our fifth case. This case was an appeal to the Inner House against a Sheriff's Court decision. The court was required to determine at which point the defender's obligation to make payments under a contract came to an end. The key issue was the proper interpretation of the phrase completed and commissioned, and whether this should be interpreted narrowly as set out in the payment clause, or more broadly to incorporate other terms of the agreement. The dispute concerned an agreement regulating the shared provision of services to facilitate house building developments on neighbouring sites. The parties had agreed that the defenders would install drainage systems on the pursuer's site and that the pursuers would then be entitled to connect their residential development to these systems at no cost. The parties also agreed that the defenders would use all reasonable endeavours to ensure that the systems would be completed and commissioned by a long stop date of 28th of March 2008. The court needed to consider the interpretation of the clause which entitled the pursuers to a £5,000 a month penalty, which was not challenged as unenforceable under the penalty rule, which was to be paid by the defenders for each month after the long stop date in which the systems remained to be completed and commissioned. The systems were not completed by the long stop date, and accordingly the defenders made payments to the pursuers at the rate of £5,000 per month up to and including December 2008. On the 13th of February 2009, the defenders wrote to the pursuers advising that the defenders would no longer make payments because the system was now installed and connected to the public system, and the water system was, for all practical purposes, complete and operational with the requisite capacity. The pursuers did not agree that the works were complete. The pursuers' principal argument was that the proper interpretation of the phrase completed and commissioned fell to be made by reference to another clause in the agreement, which required the defenders to notify the pursuers within 21 days of the sewerage system having been fully completed to the satisfaction of all relevant statutory authorities. Such notification had not been given, as the relevant statutory authority, Scottish Water, had identified snagging issues with part of the works remaining for some considerable time after March 2008. Therefore, despite those works being otherwise operational, the pursuers contended that this meant that the works remained incomplete and uncommissioned, and therefore the monthly payments continued to be owed. However, the drafting in the agreement did not use the same wording in each clause, and it was held that by using different language in different clauses, it logically followed that the meanings of the two clauses were intended to be different. The meaning of one clause cannot be held to apply to the interpretation of the other, and the clauses were to be read separately. The court also considered that the commercial purpose for the clause imposing the payment for failure to complete by the long stop date was to address any financial liability the pursuer would incur as a result of their development being complete, but being unable to sell the houses because they were unfit for occupation. The court therefore found it would not be proper to interpret the clause as applying to the extent that the system built by the defenders was not at an adoptable standard. The interpretation of the term complete was held to mean operational in the circumstances, and therefore the fact that occupants were able to reside in the pursuer's development and all the occupants had an operational water and sewerage system meant that despite the system not yet being of a high enough standard to be adopted by Scottish Water, the pursuer could not rely on that fact to continue to claim the additional payments on the basis that the system is not complete. Lord Brodie provided some helpful guidance on contractual interpretation regarding interdependence of contractual terms and the importance of the natural meaning of language in interpretation. First, he noted that construing a particular provision requires examination of other provisions, and it would be wrong, as a generality, to read a provision in isolation. However, the result of an examination may find that provisions interrelate to a greater or lesser degree. Some may be interdependent, and some may be freestanding. He said that it would be more readily apparent that provisions are interdependent where their drafting is coherent and consistent. Therefore, just because similar wording is used in different clauses does not mean that they will be given the same interpretation. Lord Brodie also gave a clear defence of the importance of treating different wording differently. He said that generally, when one is construing a text of any sort, if different words or combinations of words are used, then it is to be presumed that different meanings are intended. He also said that he accepted that if words are unclear or drafting is poor, the more ready the court can properly be to depart from the normal and ordinary meaning of the words. However, he warned that this does not justify the court in searching for or constructing drafting infelicities in order to justify a departure from the natural meaning. This case once again highlights the need for clear and concise drafting, and for the document to be read as a whole to identify where clauses are intended to interrelate, but the drafting does not achieve this. More importantly, be consistent with use of wording throughout the document if the intention is for phrases to be interpreted as having the same meaning.
The final case is Armchair Answercall Limited and People in Mind Limited, where the English Court of Appeal considered the doctrine of frustration. We will begin with a brief review of the law. Frustration occurs when an external event makes the performance of a contract impossible. The effect is that it relieves parties from future performance under their contract. A classic example is where a leased property is destroyed by fire. The building no longer exists, making performance of the lease impossible. The lease is therefore frustrated. There are two ancillary rules to remember. 1. Parties are free to contract out of the operation of frustration, and it is usual to do so when agreeing a lease. 2. Frustration does not affect the parties' obligations prior to the date of frustration. The legal test was laid down by Lord Simon in a 1930s case called Davis Contractors Limited and Fairham Urban DC. A frustrating event must be 1. Without default by either party, 2. Not contemplated by the contract, and 3. Supervening, meaning that it occurs after the contract has been formed. The rationale is that the nature of the outstanding contractual rights and obligations are altered so significantly by this external event that it would be unjust to hold the parties to the contract. So turning to the facts in Armchair Answercall. People in Mind took over the management of a company which provided call centre services. Their clients were managed by franchisees. To accommodate this change, People in Mind retained the services of the managing director of the former company to transition the existing franchisees to the new structure. This contract was for 12 months, and the services were provided through a nominee company, Armchair Answercall. The transition went poorly, and as a result, the franchisees all left the company and set up a competing business. The contracts between the franchisees and People in Mind were all terminated. People in Mind then refused to pay the monthly fee to the consultant, Armchair Answercall. They argued that Armchair Answercall's contract had been frustrated when all the franchisees left. The court considered that the definition of transition under the contract with Armchair Answercall included more than People in Mind thought it did. When all the franchisees left, People in Mind could recruit new franchisees and customers and use Armchair Answercall services in that process. Further, the way a franchisee was treated during the transition negotiations contributed to the departure of the franchisees as a whole. The supposed frustrating event was, at least in part, the result of the acts of Armchair Answercall, whether or not they can be said to amount to fault. The contract, placed in its context, must be taken to have contemplated that the franchisees might not be persuaded to transition to the new business. Their departure was foreseeable. The court therefore held that the contract was not frustrated. So what can we take from this case? Well, in reality, frustration is rare, and it is hard to satisfy the courts that the test is satisfied. If you are negotiating a contract that is likely to be affected by changing circumstances, such as shipping, registrable leases, construction contracts, it is advisable to contract out of frustration. Consider what you would want the legal consequences to be if the worst were to happen, and provide for that in your contract. So that concludes today's webinar. Thank you all for taking the time to tune in and listen. Your speakers today have been Alison Rochester and me, Daisy Bovingdon. If you have any questions or would like to discuss anything arising out of today's webinar, please do contact us using the details on the slide. There is another related webinar series that you may be interested in, which traces the life cycle of a contract. The series is already underway, and you can sign up for the remaining webinars at our homepage, www.shepwed.com, under the heading Events. You can also catch up on the podcast for the first few episodes there. So thank you all for listening. Alison and I look forward to welcoming you again next time. Good afternoon.